commence our first panel on the relationship between public regulatory enforcement and private securities class actions. We're really lucky to have a great panel with us. We have Jim Cox right next to me, who's the Brainerd Currie Professor of Law at Duke Law School and an expert in securities regulation and class actions, with a particular recent interest and expertise, or long-standing actually, but he'll be talking about some of his expertise in accounting and auditing. Next to him is Joel Rochon, founding partner of Rochon Genova, leading class actions lawyer in Canada. Next to Joel is Wendy Berman, senior partner at Cassels Brock Blackwell and a leading securities litigator in Canada. And then finally, last but not least, Adam Pritchard, Francis and George Skestos, professor of law at Michigan and an expert in corporate and securities law, particular expertise and interest in empirical work and comparative work. And so we're delighted to have all of you here. The focus of this panel is about the respective roles of public regulatory actions and compared to securities class actions. Are they complementary? Are they unnecessarily duplicative? Are there gaps in relation to each one of those frameworks that can be filled easily and well by the other? Wondering if we can start off with Joel and with Wendy to speak briefly about the AIC and Fisher case, what it stands for and why it's important. Joel, you were counsel in that case. Wendy, you were also involved in that case in some stages. Perhaps you could just speak briefly about why it's important.
Thanks, Poonam. Pleased to be here. Just a couple words about the Fisher case. Limited to 10 minutes, perhaps I'll turn it into 2 or 3. Please do. But this was an important case, not only from a class action perspective, but even before the class action got going. I'm not sure if Monica was at the commission at the time, but this case was a big case, a big deal, I was going to say, it was so colloquial, in that it involved, at the time, quite a substantial settlement in terms of dollar value. But it wasn't only the dollar value, but followed on the heels of a lengthy investigation and prolonged negotiations with 5 mutual fund companies. And add to that, it wasn't just a penalty that was kind of arrived at the end of the day. There was also provision for compensation flowed directly to investors. And I know Monica mentioned it in her opening remarks, but at the time, that settlement that the OSC negotiated was historic for many of those reasons, the size of it and the fact that this compensation is flowing right down to the investor level. So that said,
at no cost to investors.
At no cost to investors, because the commission doesn't do contingency fee work. I think if you're on a salary, it's like a taxpayer expense. But anyway,
the other thing that was at no cost was the calculation of the harm, and you had the expertise of the OSC. So we'll just get into our debate right now. The expertise of the OSC with external advisors calculating harm to investors.
When we took a look at the case, we consulted economists from the U.S. and Canada, and came to the conclusion, based on the information they were telling us, that although the OSC settlement was a good start, down payment, some would say, unfortunately, considerable money was left on the table. And not only that, but the process, the OSC process, did not engage individual investors at a direct level. And so those were 2 things that concerned us. In any event, we moved forward with the class action and ultimately had a certification hearing. Wendy and her partner were involved in that case on behalf of one of the mutual fund companies. There were 5 in total, as I mentioned. The case went through certification. Unfortunately, we did not have success at certification. The judge was interested.
Very wise man.
Very wise judge, Mr. Justice Perel, one of the leading class action judges, as people know, head of the panel here in Toronto. But he determined that the OSC is a specialized organization that they essentially took on the mantle of class counsel, and what do you know, they came up with this fabulous settlement, $200+ million, and got the money distributed at a no-cost basis. So we took that case up to appeal. The divisional court focused on the substantive shortfall of about $750 million when you count all five, based on Eric Zitzowitz's calculations, our expert from Stanford. And not only that, there were participatory issues that I mentioned, but the Div Court didn't focus on that. That was addressed primarily by Mr. Justice Winkler, the then Chief Justice in the Court of Appeal, who focused really on the lack of participatory elements, the lack of transparency in terms of the methodology of the calculation of the damages, the fact that most of the hearings were held in camera, although there was short notice given. All that was held to be deficient. The defendants moved it up to the Supreme Court of Canada, and that's what I wanted just to say a couple of words about here today. At the Supreme Court of Canada, they took sort of a typical Canadian perspective on this and said, look, A, we need to work together, we need to cooperate, and the OSC and class counsel and class actions can exist harmoniously together. There's no need to have winner take all in terms of the respective functions. And so they focused on that harmony as between the two groups. Because let's face it, Monica touched on this in her remarks, there are limited resources, and having sort of deputizing class action lawyers to get out there and try to bring home some positive results for investors to enhance investor recovery is a good thing. And the work that the OSC did in that case was also a good thing. But unfortunately, there was money left on the table. Let the class action lawyers see what they can do in terms of bringing further compensation home in an open and transparent environment. The other thing the Supreme Court did is they took a broad interpretation to the access to justice question and opened it up to both the substantive shortcomings in terms of access to justice and precipitatory rights, I said that very well, in terms of getting the investors engaged. After all, these are the clients of the mutual fund companies, and they are the people that we represent in the class action process, the cases moving through discoveries. Quick takeaway, listening to Monica's comments, this brought this top of mind, and that is what the Supreme Court of Canada did is they prevented a situation whereby an issuer could go to the OSC, cut a deal with them, and then it would be immune from facing further litigation down the road. It would be an immunity process in its darkest light. And the Supreme Court of Canada recognized you need to look at these cases, consider the facts of each case individually, and come up with a resolution or a decision on the access to justice question that really moves things forward in favor of access to justice and the investors. So those are my preliminary comments about the Supreme Court of Canada decision.
Thanks,
Fisher.
Joel. Wendy, do you want to share your thoughts on
Sure.
this case?
I'm dying to share my thoughts here. So where Joel and I will agree is I think there's a place both for public and private enforcement to address share investor harm. Where we disagree is whether or not is what has happened as a result of the Fisher case all the way to the Supreme Court of Canada. Because what you had in Fisher was you had the OSC taking on the mantle of an investor compensation program. And that's what they did in market timing. And it was a significant settlement, $205 million. It was an adversarial process leading to that settlement where the OSC retained its own outside external economist to help calculate the amount of harm. The OSC was of the view that there was full compensation. As we all know, there are different ways to quantify economic harm. And so there will always be the specter of money left on the table. And that should not have been the driving force for our courts, because whether or not money is left on the table, there's no balancing of the fast, efficient, no-cost resolution for investors that came about with the settlement in market timing. What you have now is only one game in town, which is private class actions, because what issuer is going to agree to a settlement and a process, a very expensive process with the OSC, to come up with an investor compensation scheme when there will always be the chance of a class action that somebody will argue there's more money left on the table. And I think, in my view, the specter of investor participation in the process is a bit of a straw man. At the end of the day, in a class action context, Mr. Rochon represents the investors, and they do not participate individually to any great extent in the class action context. In the case of market timing, who better than the OSC that has the power to bring issuers to their knees, as they did in market timing, and to pay compensation. So now what we have is a process where there's essentially a chilling effect on the ability of the OSC to come up with a creative solution, because don't forget, the OSC does not have the power on its own to award compensation schemes. Those must be done voluntarily through negotiated settlements. And so I think what we're left with is a balance that's gone the wrong way. I don't know if I can say it any more strongly than that, but I think that's what's happened, because, and I meant to check, and I don't know if anybody in the audience knows, in the TD Waterhouse case, now again, not a settlement of the same magnitude of market timing, a $13.5 million settlement. But, I often think what would have happened if the OSC had been willing to put the word full compensation in the settlement agreement, complete compensation, would we have ended up with 10 years of litigation at cost to investors, ultimately who will bear that cost out of whatever resolutions obtained in the class action proceedings. So in the TD Waterhouse case, I don't know if there was a contemplation of a release, or there was stronger language in that settlement agreement that gave TD some comfort that they wouldn't be facing a piggyback piece of litigation.
It's a good question, and if anyone in the room has any insight on that, that would be terrific. Let me follow up, Wendy, with another question in relation to the asset-backed commercial paper crisis in Canada. You were involved in that file, and the end result was that we restructured the asset-backed commercial paper market in Canada, but there were releases that resulted in releases against liability for all of the actors involved, preventing class actions. I'm wondering if you could comment a bit on that process, the fact that class actions were pushed out of that restructuring, and also to the extent you have any insights on the distribution of fines. So there were fines collected by the OSC and IROC, and then they were distributed to investors. So any thoughts or reactions on that process?
So the restructuring of the asset-backed commercial paper in Canada was a very complex proceeding, and it used a unique solution through the CCAA, or restructuring and insolvency legislation in Canada. Now, under our CCAA legislation, there are much broader discretion and power granted to the judges in that case. And so what you had was, you had that $35 billion market completely restructured with new notes that came out at the end of that. And you needed the participation, because of the complexity of asset-backed commercial paper, of all of the market participants who brought that product out. So, just to give you a little bit of the spectrum, asset-backed commercial paper before 2007 was a very sealed black box. So investors participated, bought the commercial paper issued, did not know what the underlying structure, what was inside the black box, what that paper was secured by, what the collateral points, what the liquidity provisions were. All of those details were relatively sealed in a black box, with the result that we felt the reverberations that went on in the U.S. when people became very afraid of subprime mortgages, that type of market sentiment led to the freezing of the Canadian market, notwithstanding that there was not a large proportion of the assets in the black box being subprime mortgages. So what a committee of market participants in asset-backed commercial paper did is they came up with this unique solution to restructure the paper. So at the end of the day, what you had was entirely restructured notes, which were given out to the holders of those notes with longer terms and other changes to address the discrepancy, and the timing discrepancy which caused the paper not to hold. You had a full refund given to holders of notes of less than $1 million, which essentially made the retail holders of notes whole. And then you had every market participant involved in getting that paper out to market, participating in the restructuring of the notes, including my client, DBRS, who rated the $35 billion market. They rated the new notes. So everybody who came in participated and put something on the table to get the restructured notes out. And the reason that's important because the settlement involved comprehensive third-party releases for every market participant that assisted in the restructuring of the notes. That was challenged all the way to the Court of Appeal. Leave to the Supreme Court of Canada was sought and denied, so we finally got some clarity that third-party releases in the context of a restructuring will stand. And that's the only real way you could get everybody to the table participating and taking some hit on the chin to get the new notes out. The other interesting thing is the securities regulators, I'll just finish the last piece. So securities regulators, both securities commissions, IROC, took proceedings against the banks and the dealers who sold the paper and obtained significant settlements. I think the total amount in settlements was $140 million, of which only $60 million has been distributed to, I believe only $60 million was distributed to investors through a compensation program approved by the courts. And so that's where you ended up. That was your question?
Did you have a question?
I have a question.
Okay, we'll get you a piece of paper and a pen. Thank you. Joel and Wendy, thank you for those remarks and I think laying out some of the policy issues or the tensions in the Canadian context. Adam, if I can ask you now to spend a couple of minutes going through some of the data you have on U.S. securities class actions. This is going to work.
All right. So one of the questions that is at the forefront of the policy debates about securities enforcement and both public enforcement and securities class actions is the deterrent effect, right? The ultimate goal would be to discourage others from engaging in fraud. And I have done a bit of work with Steve Choi on the question of comparing the relative precision in targeting fraud by the SEC and by securities fraud class actions. So Poonam wanted me to share a little bit of that with you. So we looked at investigations that the SEC did between 2004 and 2007 involving public companies, because those are the companies that would be targets of securities fraud class actions as well. So we collected essentially the population of SEC investigations from that period of time, and also the securities class actions that were filed during that period of time. So one of the oddities of the enforcement regime is that you can be subject to both an enforcement action by the SEC as well as a class action by the plaintiff's bar. And for our period of time, 462 investigations initiated by the SEC where just the SEC proceeded, 430 class actions where there was just a class action, and then 240 cases where the public company was facing both a class action and an SEC investigation. So just a bonanza of work for the defense lawyers in those cases. And one of the things that stands out in the both category is that nearly more than half of those cases involved a restatement of financial numbers by the company. So the initiation of all that legal trouble was the auditors of the company saying, you haven't done it right, and you have to restate the financials. So the other thing that stands out among those numbers is the size of the company. So it is sometimes thought that the SEC has an important role to play in pursuing smaller companies that the plaintiff's bar can't be bothered with. That's not actually borne out by the numbers. The average company size is smaller for the class action alone category than it is for the SEC only category. And the other thing that stands out is the class action bar. They're focused on the companies that are struggling, that have shown poor returns. For the SEC, that's not true. So the first thing we compared was, what's the stock price reaction? How does the market react at the time the wrongdoing or bad news is revealed? And the class action bar is much more focused on the large stock price drops. The average stock price drop is 11% for those cases. The SEC only category, it is a negative reaction, but only less than 1%. So these are problems that the market does not perceive to be very significant, is where the SEC is going it alone. So stock price responses are a little bit of a messy figure because much of the reaction may be to your business is not doing as well as we had thought, so you need to revalue the company, as well as the market's assessment that you are not a truth-telling company engaged in fraud, which also causes them to revalue the company. So we looked at some other measures that we think are proxies for the trust that the marketplace has in the disclosures of companies. How much of a response is there to unexpected earnings announcements? What is the change in institutional ownership? The hypothesis is that institutional owners might be more sensitive to fraud, more likely to flee the stock of a public company accused of fraud. The bid-ask spread, the financial economists say that when there is more information asymmetry between outside and inside investors, the bid-ask spread will increase to compensate traders for the risk of losses in trading. And then the final measure we use is, did the board fire someone in connection with the scandal on the view that the board has access to better information about whether or not there was actual fraud because they have an internal investigation to proceed with. And our hypothesis is that for the SEC investigations, SEC is not driven by a profit motive, right? They are presumably pursuing their investigations based on their best assessment of the public interest. These reactions should all be stronger for the SEC than for the class action bar, right? Because the class action bar, we saw they are at least a little bit interested in large stock price drops, which may or may not correlate with the existence of fraud. You're not interested in large stock price drops, right? You don't pay any attention to them at all.
Not unless the company begins with a B.
So there are the predictions, right? That they see a greater decline in earnings response coefficient. Institutional owners will exit the stock more. And here are the results. The earning response coefficient, less of a response for the SEC-only actions. Institutional ownership, less of a decline for the SEC-only actions relative to the class action suits. The bid-ask spread declined less for the SEC-only actions compared to class actions. And there was less likelihood that an officer would be terminated if the SEC was pursuing the case and the class action attorneys were not following along. All of these figures were greater for the situations where both the SEC and the class action bar proceeded, right? So we had that core 240 cases where there was a consensus between the private lawyers and the SEC, which are clearly the strongest cases that are being brought. But then you look at the other categories, the class action only cases look a little bit better than the SEC only. So, well, maybe the SEC's got there first, right? So maybe that's the value added. No. The SEC, in the cases for the both category, they're about equal. The SEC shows up for the class action lawyer shows up. So in terms of initiating cases, it's about the same. So the research question, do we have reason to believe that the SEC is more accurate in targeting fraudulent behavior than class actions because of that absence of the profit motive? And our general conclusion is no, that if anything, the evidence is to the contrary. This is a much more famous mem in the United States than here in Canada. She got the silver medal. She's kind of bummed. She thought she was better than that. So the SEC not getting the gold medal in our contest. The both category is clearly the strongest set of cases, but of course we shouldn't feel great about that. The strongest set of cases is initiated, more than half the cases, by the auditors demanding a financial restatement. So in terms of revelation of fraud, that work is being done by the auditing function, not by class action attorneys, not by the SEC. So query why the SEC doesn't show up better on the metrics that we have for targeting fraud. One hypothesis is, and this could be worth further investigation, maybe the SEC has too many tools at its disposal, right? It is not limited to pursuing only fraud cases. They have various negligence counts that they can bring against public companies and their officers. Those cases may not be as strong on the merits. So this is just talking about targeting, right? We're not talking about the deterrent value of the actions, which is much harder to measure. And one of the things that doesn't happen in class actions is that individuals don't get sanctioned. So the ability to sanction individuals is an important feature of the SEC's enforcement power. All right, and I'm going to stop there. I'm going to save the other for after.
Perfect, I think that's terrific. Jim, I'm wondering if you can pick up on some of the comments that Adam made. He was talking about the role of auditors, and I'm wondering if you might be able to speak about the quality of financial reporting. How has the regulatory model for auditing worked so far since Sarbanes-Oxley created the Public Company Accountability Oversight Board, PCABO, as it's known to some, and the Canadian equivalent, of course, is CPAB, the Canadian Public Accountability Board. And the reason I ask this is because auditors are so involved in the context of the capital markets and then in the context of securities class actions.
Well, you know, we really don't know the quality of reporting except circumstantially. That's what the tremendous benefit of empirical work that Adam and Steve are doing and others have been doing. I mean, our priors would say that certainly since 2002, when Sarbanes-Oxley came in following an earlier crisis in financial markets in the United States, that we would think that quality reporting should be better, okay? And, you know, we have auditor attestation for large companies and evaluating internal controls. We've professionalized the audit committee in the United States so that we have individuals there who know something about the more than the debits on the left side where the windows are. We have engagement partners being rotated on a regular basis. The member of audit committees, I think that's a strength, quite frankly. And we have a new independently funded and revitalized audit standard setup in the United States, the Public Company Accounting Oversight Board, where essentially they took it away from the auditing industry and put it into an independently funded committee. All of that points out fairly well. One of the things that PCAOB has been doing, and I think it's the inside of it, is that they carry out inspections on a fairly regular basis of registered auditors in America. Here we start having some disquiet. When you look at the big four, and we're, you know, I come from basketball countries, so we refer to it as the Final Four, okay? Big four accounting firms, that you find that of the inspections that were conducted last year, there were 52 inspections of Ernst & Young, for example. 46% of those had major deficiencies to it. Not just one major deficiency. When you look at the mode of the deficiency, the number of mistakes, 5 would be the mode in terms of the number of deficiencies within the inspected companies. That's fairly disquieting. Now, E&Y is at the apex of those, At the lower end is 1 out of 4 of the audit clients that were inspected, Pete Barber, were deficiency inspections. So 1 out of 4. This is disquieting. This is very disquieting when you think about it. And then as you go down the pecking order, you see the so-called second-tier accounting firms. Their numbers are even more alarming. So we're not making the headway that we ought to be going there. And so what we see is an attempt to try and further strengthen things. And the time I have remaining, I'll talk about what's on the agenda for the PCAOB. And that is trying to take the audit opinion letter. We're all familiar with that. It's an up or down sort of opinion, like a light switch. The lights go on, the lights go off, okay? And the question is, can you make that a more robust opinion letter in communicating information? Those of us who serve on audit committees know that the questions you ask your auditor, if you're being a responsible member of the committee, and those that are mandated on companies in the United States are the following. You kind of ask the auditor, what keeps you awake at night, okay, regarding this audit claim? And you probe that. You kind of ask questions you're expected to ask, as an audit committee member. What are the critical accounting estimates, judgments, and assumptions in this audit? So that if you change one of those estimates or you change one of the assumptions, then suddenly you made your fourth quarter earnings and you didn't make it. What's really important there? So that's been going on, and at least on the audit committees I serve on and others I talk to, all believe that that's happening. Can you make that become public? How do you do that? I mean, it's a tremendous problem because the minute you start taking what happens in that audit room and you start moving into a public statement, the issuer loses control of that, the engagement partner loses control of that. You're not going to have free writing of these statements. You're going to have those happening at the Chicago or the New York office of the accounting firm. And they're all going to look the same. Milk toast, boilerplate, etc. It's going to be indistinguishable whether you're talking about Intel or IBM, whoever's. Okay. So that's a tremendous challenge to figure out how you can get that communication through. The battle that's been going on, as we know, in the United States, we've lost that battle. We're not going to have rotating of audit firms. We only have rotating of engagement partners. But probably pretty important to know who that engagement partner is. That's a huge battle going on right now about who's going to be the engagement partner, because the investor community would like to know that whether you have the same engagement partner that's accommodated these 5 deficiencies for this firm and that firm, etc. So that is a critical. Another question: how many firms got going concern qualifications in their audit opinion letter in December of 2008? We all remember 2008. The wheels come off the cart, right? The answer is 2. It's incredible. Here the federal government bailing out the banking industry and the brokerage period left and right. Okay, they're lining up the discount limit quietly. Okay, keep them alive, and the auditors are not qualifying to go into securities. Anybody who knows anything about accounting understands that an asset doesn't exist if there's no tomorrow. Okay, and everything sort of goes through how you're going to assign this cost by what's an asset. So that's a battleground that's going on. And so there's a tremendous amount of developments here. And as a result, if I could just have another 30 seconds here, and that is that the 4 report cards the Big Four is getting and the near accounting firms are getting have created a political pushback in Washington, D.C. right now, so that the threat to the PCAOB is fairly significant. And so if I were to return in 5 years' time, I may have a somewhat different report to you about the contributions that I believe the PCAOB can make. But right now, I'm very optimistic about the agency, but I do think it is one of the best, if not better, performing agencies within Washington, D.C.
Thanks, Jim, for that update and those insights. I'm wondering if we can now turn briefly to non-securities class actions involving investors. Adam, I know you've written a paper on this, and Jim, you have some views on deal-related litigation and forum selection bylaws. Wondering, Adam, if you could just share your thoughts on non-securities class actions involving investors.
Happily, I've got some slides for you. So this is the latest project that Steve and I are working on, looking at corporate lawsuits that are filed in tandem with securities class actions. So we recruited Jessica Erickson to work on this with us because she knows a lot more about derivative suits than we do. So here we're looking at securities class actions filed roughly that same period, 2005 to 2008, and then we identified whether there was a derivative suit filed based on the same allegations, right? So comparing the complaints, are they based on the same misconduct? So who files first in these cases? So about 80% of the cases in which there's both securities class action and a derivative suit, the securities class action gets filed first. In the U.S., when the plaintiff's firm files a securities class action, they have to issue a public notice saying that they have done it. This creates an opportunity for a derivative suit plaintiff attorney to do some cutting and pasting and put together a complaint of their own, alleging that the directors and officers have breached their fiduciary duties by allowing this misconduct to go on. So most of the cases, the securities class action goes first. We term this piggybacking, so we're getting an additional suit based on the initial suit. So when do the derivative suit attorneys show up to bring these cases? The answer is when there's been a government investigation into the misconduct, and when there has been a restatement by the company. The auditor has told them they need to restate their accounting statements. That's when we have a higher probability that we will get a derivative suit. So we have situations where either the government or the auditor is looking at it, that has prompted a securities class action, and when it rains, it pours, you're also going to get a derivative suit, more likely to get a derivative suit in that situation. There is some evidence that they are looking to when top officers have been involved in litigation in selecting to bring the derivative suit as well. So the cases that are most likely to generate a settlement, once again, when there's a government investigation, when there's been a restatement of the financial returns, those are most likely to generate a settlement. The busiest attorneys are the ones most likely to generate a settlement. You're thinking, okay, they're good at what they do. Hold on. We call these the frequent filer attorneys, and they are better at generating settlement. But the settlement amount is not greater for the top 10 attorneys. It is greater when there has been a bigger settlement in the securities class action. So when you pay more in the securities class action, you're also going to pay more in the derivative suit, and you're also going to pay more when there's been a restatement. So in terms of the additional deterrent effect, right? Maybe this is the worst misconduct, you're paying the highest price, but you have to question whether we need to have the separate suits in order to get this done. Maybe we should be recalibrating the damages in the securities class action and doing away with these if that's what we want. So one of the features of derivative suits, and maybe Jim is going to talk about this as well, is a lot of these suits settle for no money dollars, no money payments at all. The company agrees to make corporate governance changes to avoid the wrongdoing in the future. And there are our friends, the busiest top 10 attorneys in this space. They're the ones most likely to settle cases for a corporate governance settlement. So I told you before that they were the best at generating settlements. Here's the explanation as to why they're willing to settle for no dollars, right? They're willing to settle to have the corporation make some changes.
Thank you, Adam. Jim or anyone else on the panel would like to share?
Well, very briefly, so there was a study made not very long ago that acquisitions, we know that acquisitions have been quite crazy for a variety of reasons, cheap money being one of them. Acquisitions involving over $100 million, 92% have faced litigation, shareholder suits that are questioning the acquisition on a number of bases. And what's disturbing is a significant number of those that litigation is not just 92% of the acquisitions involve shareholder suits. They involve shareholder suits in multiple jurisdictions. 3, 5 is a notable number out there. And so you have this phenomenon that's developed in America. Oh, why is this litigation? There's a number of reasons like that. One, we have something called the American rule. You probably think we have nothing but American rule. But we have American rule, which means that people pay their own litigation costs, and so it's not a loser pay phenomenon that you find lots of other places. You also find that many of these suits are driven by Delaware jurisprudence, which puts a number of bullseyes, and not just one, but signs on an acquisition that says "sue me," and that all developed in the happy '80s, which I think Delaware is now ruling the day that this has probably happened, except the Delaware lawyers think it's a very good deal to be defending these suits. And so these suits going on. So the development there that's happened are called form selection bylaws, and that is that Delaware Board of Directors adopts a bylaw that says we have the option, Board of Directors of this company, to decide whether you're going to be suing us in Paducah or in Wilmington, Delaware. And we get to choose where we want to be sued. And those form selection bylaws. And this got legitimated by the Delaware legislature authorizing form selection bylaws. And so they're ubiquitous for American corporations, not just those in Delaware, but across the land, in which you can have the unilaterally adopted bylaw by the Board of Directors that gives the board the option about what venue will be sued in. And the question is, well, how, what else can you do in these form selection bylaws? Well, something that happened in a nonprofit in the APT Tour case was to say you can have fee shifting, otherwise get rid of the American rule and shift the fees over to the initiating plaintiff, and that has a nice chilling effect, and Delaware Supreme Court upheld that. That gets reversed by the Delaware legislature, but it still remains to be seen how many other things you can change in the bylaw arrangement, like maybe you have to, before you create a shareholder suit, you have to be a shareholder for X number of times, say 30 years, to bring a suit. Or maybe you can't have any inspection rights related to corporate books so long as you are maintaining a shareholder suit. Lots of things like that. So it remains to be seen what the board's power is to unilaterally adopt a bylaw that changes historical and fundamental rights of shareholders. So that's a matter of some concern.
Absolutely, thank you. Wendy, anything to add here?
I'll just add the Canadian experience so far is quite different when it comes to shareholder actions following major acquisitions. So we see a lot of that litigation happening before the commissions rather than before the courts. And we don't see as many class actions that come as a result of an acquisition transaction. So we don't have that quite the same way. In terms of derivative actions, again, we don't see the piggyback here. We see a securities class action commenced, but not a piggyback derivative action. And in most of the large Canadian financial disclosure cases, you would see the securities regulators stepping up the plate to bring about the corporate governance changes that are required to avoid the restatement or whatever was the recipe that allowed for the financial disclosure to be inaccurate at the time it was made, not derivative class actions. But like many things, we often follow our U.S. counterparts, although we won't call it the American rule when we do.
Jim, one last word on this?
Well, just briefly, it's kind of fun to watch Delaware walk this tightrope. I mean, I did some back-of-the-envelope calculations to figure out how much of the GDP of Delaware was explained by the corporate practice law, litigation, what have you. And, you would kill the restaurant industry, okay, if you had wide selection of arbitration. Because nobody's going to, you've been to Wilmington, you don't want to arbitrate a case there. San Francisco, New York, Toronto, but not Wilmington. Okay. So there's huge implications for the state of Delaware, okay, well beyond just the franchise taxes. If you suddenly, kill the goose that's laying the golden egg, and that goose is litigation in Delaware, okay, in the story.
Thank you. We just have a couple of minutes left. I have 2 questions here on our electronic platform. I encourage you to put in more questions or write them down and bring them up to the front. 2 questions here. In the asset-backed commercial paper crisis, why weren't the ABCP note makers included in the restructuring process? If they were, please explain the implications. I don't know if anyone can answer that or is able to answer that, or if not, then we can have a conversation with whoever posed the question at break, and I don't have a name for the person, but.
So if by note makers, you mean the conduits that actually issued the commercial paper, they were included in the restructuring, and it was their notice that we were restructured. So whoever asked the question, if they want to come up later, I might understand a bit better than the included makers.
Okay, terrific. Second question, do you see the bed for legislative intervention to essentially back up the OSC's powers to reach settlements with issuers to counteract the chilling effect of Fisher that you described? This is Saeed TV. Any thoughts?
The chilling effect of Fisher.
You don't like that?
Well, I don't think there is a chilling effect. I was going to jump in when Wendy was
Eloquently
responding
describing the chilling
to
effect.
some of the points that the Supreme Court of Canada put to rest, I had thought. But in particular, issuers will always come and deal with the OSC. And Fisher in no way neutralized the power of the OSC in that regard, because the OSC still under Section 127 has the power to pull the ticket of the issuer. So notwithstanding Wendy's eloquent kind of response to Mr. Justice Cromwell and the Fisher decision, I don't think it's going to change anything in terms of the alchemy that we saw prior to Fisher, except it puts another tool in the toolbox of investors to try and enhance investor recovery. And I think that is the most important thing that flows out of Fisher.
Thanks. I have another question on sanctions collection. Wondering if you might be able to speak on the Canadian experience, Wendy or Joel, and on the U.S. experience, Adam or Jim, in terms of the important policy questions regarding sanctions. So Jim, you might have some thoughts on this in terms of what the SEC does, but also sanctions collection. How much do we actually end up collecting, and what does this mean in terms of our overall policy goals?
So I don't have the statistics with me right now, but in terms of in Canada, the collection rate for sanctions is quite low. And again, Fisher is quite different. Fisher was a voluntary compensation scheme, or it was a voluntary settlement which involved a compensation scheme. So that entire $205 million was paid into the compensation scheme. But when it comes to collecting sanction money, securities regulators are quite low in Canada, much lower than our U.S. counterparts.
Thank you. American perspective on sanctions or sanction collection?
I think on the sanctions collection, Monica explained it quite well during her remarks, is that the hardcore fraudsters, the criminal types, have made off with the money. So Ferraris have been purchased, money has been sent to the Cayman Islands, and until you know of the fraud, you can't take the interventionist steps of getting a receiver appointed, et cetera. And by that time, a lot of the money has gone. In the U.S. context, the collection rate fluctuates between 40 and 50%, maybe somewhere in that range. It's bolstered considerably by penalties assessed against large financial institutions who always pay every last dollar. Apparently they want to keep their license, so they're willing to pay. The Ponzi schemers don't pay.
I would just add to that, if I could, that as painful as it was to see, for example, the Frank Dunn Nortel trial kind of blow up and not end up in a positive resolution for the regulatory environment as a criminal prosecution or quasi-criminal involving some of the executives of Nortel Corporation. I would just urge the OSC to end the IMET and the new iteration of IMET that Monica talked about this morning, to continue focusing on kind of the bigger problem children out there, and not sort of focus so much on the low-hanging fruit involving the small sort of mom-and-pop organizations that might net you $500,000 on paper and they can only pay $25,000 in terms of fines. The larger ongoing concerned corporations should also be targeted and continue to be targeted, notwithstanding some unfortunate setbacks in recent years.
Thanks, Joel. And then we have one last question from our participants, from Barb Amston. Excellent panel. Background for this and future panels. Could we get a sense of the numbers of enforcement actions? That's a fair point in terms of the public regulatory actions. And then SEC just released 807, if I'm reading the question properly, and the CSA seems about 130 or so. Are the numbers comparable? If not, why not? So I think your question relates to, is Canadian securities regulatory enforcement at the same intensity as U.S. securities regulatory enforcement actions? Obviously different numbers, but how do you compare? Any thoughts or reactions? It's certainly something we'll talk about in other panels during the day as well. I think that's what your question is suggesting, Barb.
I think it's a great research question, and I would encourage the Canadian securities regulators in attendance to cooperate with researchers who might like to bring empirical light to bear on that question.
And Adam will be first in line there. One of the participants who was supposed to join us today, Howell Jackson, who couldn't be here from Harvard, actually did a study a couple of years ago. He looked at budgets of Canadian securities commissions and compared them to budgets of U.S. securities, the U.S. SEC, as well as regulators around the world. And he found that when you take appropriate deflators into account, such as GDP and population and so forth, that in fact Canadian regulatory intensity is about equal to U.S. regulatory intensity. So that now that study's from a few years ago, so certainly would be worthwhile to take another look. And his focus was on budgets rather than on actual enforcement numbers. So there is an opportunity for research and for collaboration with regulators. So I don't see any other questions on my screen. I don't see any other cue cards. I will end this panel and thank the panelists for their thoughtful and insightful comments, and we will continue this conversation